Hello, everybody, and welcome to History Slash Law Bite number 263, dated May 27th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History Slash Law Bite is entitled Weeks versus United States. Weeks versus United States, folks, was the point of origin for virtually all future Fourth Amendment case law in the United States. This is where it all began, okay? And in the 117 years since this decision was handed down, the seeds of the Weeks case have since germinated into many, many mighty and beautiful oak trees in constitutional law. So let's examine the Weeks case and see precisely what made it so significant. In this case, petitioner Fremont Weeks was arrested at a train station in Kansas City, Missouri. He was arrested without warrant, by the way. At the time of his arrest, police also invaded his private property, but they didn't have to break in as they had been tipped off by a neighbor to where the key was. Upon entering the property, they searched his room and seized papers and other articles that were subsequently turned over to a United States Marshal. Later on that day, the marshal himself returned to the property with more police officers, okay? After being let in by a third party, the marshal himself would search Weeks's room and carried away letters and envelopes and other things of interest that were found in a chest drawer. Both of these searches and seizures, by the way, folks, were done entirely without warrant. All right, the first one by the police, the second one by the marshal. All right, nobody had any warrant to do any of this searching or seizing of Mr. Weeks's private property. All right, so you're already kind of getting the gist of where we're going with this. So as such, due to the evidence that was found, Mr. Weeks would be indicted in the United States District Court for the Western District of Missouri. All right. The charge was using the U.S. mail to transport lottery tickets, which was indeed a federal crime. However, Mr. Weeks was very aware of his constitutional rights, and a motion was filed on his behalf to suppress this evidence that was obtained without a warrant and to return his property to him. Needless to say, the motion was denied, and ultimately, Mr. Weeks would be convicted for violating this federal law. As such, he would appeal to the Supreme Court of the United States. The question, therefore, presented to the justices was a simple one. Did the warrantless search and seizure of Mr. Weeks's property violate his rights under the Fourth Amendment to the U.S. Constitution? What do you think? In a unanimous 9-0 opinion, the court answered yes. Justice William R. Day, in writing for the court in Weeks versus United States, emphasized the following points in ruling in favor of Mr. Weeks and the Fourth Amendment. First, the seizure of Weeks's papers and correspondences without a warrant were a direct violation of his Fourth Amendment constitutional rights. Next, additionally, the district court, in refusing to return his property, violating his Fourth Amendment rights, as the seizure had been illegal in the first place, and allowing this evidence to be used against him, the district court had committed prejudicial error. And by that I mean, had the district court returned the property, there would not have been any substantial evidence to use against Weeks for a trial to even occur, folks. The court emphasized that allowing private documents to be seized and held as evidence against the people without, warrant authorizing such a thing would have essentially rendered the Fourth Amendment and its protections to be dead letter. And indeed, that is a very factual point, all right? If the court had allowed this to skirt, then you would have essentially made the Fourth Amendment a useless part of the Constitution. Last but not least, the Supreme Court, this is an often ignored part of the Weeks opinion. The court did not speak to the actions of the police officers here or give any remedies to Mr. Weeks with respect to what to do about them because, why do you think? Because they were local officials and they were thus not bound by the Fourth Amendment. Remember, Fourth Amendment doesn't yet apply to the states, okay? The limits of the Fourth Amendment were only to the federal government and its agencies, okay? So with that in mind, what was born from this case was what would become known as the Weeks Rule, ladies and gentlemen, which would bar illegally obtained evidence from being used against the person from whom it was seized in federal courts. All right? Now, why do I say only in federal courts? Well, remember what I just said, that at the time, the Fourth Amendment did not apply to the state governments. Therefore, the states could still skirt around the Fourth Amendment, and believe me, many of them did, all right? The Weeks Rule, which would later become known as the Exclusionary Rule, all right, would not be applied to the states, folks, until nearly 50 years later in the case of Mapp versus Ohio in 1961, all right? Now, as I've mentioned in my other videos about Fourth Amendment case law and the Fourth Amendment in general, numerous exceptions have been carved out by the Supreme Court to the warrant requirement as well as the exclusionary rule itself. Okay? Many decisions have been handed down since Mapp versus Ohio specifically that have weakened the authority of both the warrant requirement and the exclusionary rule, folks, unfortunately. Okay? So the bottom line here and the holding of this court in Weeks versus United States was that warrantless searches and seizures of private documents from a private home violated the Fourth Amendment to the Constitution, which bars unreasonable searches and seizures. And any evidence obtained in said manner was barred from being used against a defendant in a federal criminal trial. All right? Once more, warrantless searches and seizures of private documents from a private home violated the Fourth Amendment's prohibition on unreasonable searches and seizures, okay? And any evidence obtained in that manner was barred from being used against the defendant in a federal criminal trial. All right? Judgment accordingly for petitioner Fremont Weeks. Therefore, the judgment and opinion of the U.S. District Court for the Western District of Missouri was reversed and remanded. So, that's Weeks versus United States, 232 U.S. 383, 1914. Any questions or controversies, leave them down below. I'll be happy to answer them. If you learned something from this video, gained some insight, which I most certainly hope you did, drop me a like. Truly, I would appreciate it. And if you have not already done so, please subscribe to my YouTube channel so you can keep learning all this interesting stuff, you know? I mean, come on. Just hit that little red subscribe button right there and we'll be in business. Take care, stay safe out there, and I'll talk to you at the next bite. Peace.